So I'm a lawyer. I'm a PhD, and I mostly focus on the copyright and intellectual property rights. And honestly speaking, I don't like them. So this is my attitude. But today we are not focused mainly on the things that I don't like copyright, but what we can change about it in a cultural heritage or cultural sector. So we are going to have this the workshop idea. So I'm not going to work too much. The floor is yours. So in the first 25 minutes, I will ask you in your groups to think about 5 or 10 activities which should be took by the cultural heritage institution to fulfill their mission to stay relevant in the 21st century. So this is the main part of the workshop. After that, we will try to discuss this among us. And this will be next 15 minutes. So I will ask you to present what, from your perspective, what activities should be taken by the cultural heritage or cultural institution. After that, I will give you a brief sketch about the copyright, and we'll try to confront what you told us and what you think which would be suitable for those institutions, and I will try to show you how it looks in a copyright perspective, and then we'll try to make a discussion between all those two elements. So your ideas, the legal stuff, and how we can react to that. So I hope it is quite clear. And of course, I will... Okay, but yeah, it was good to hear. So this is the first task, and I want you to work with your groups. As I understand, you are now divided. So think about those kind of activities which, from your perspective, and here is more elaborate part, yeah, which should be undertaken by those cultural heritage institutions, especially in a digital environment. So what should be done by those institutions to become relevant, you know, because we don't want to have a museum which are, you know, in the 19th century, but we want to have something new. So the floor is yours, and you have 25 minutes to that, and I will, you know, rejoin the group and try to discuss those things. Okay, so as I understand, you've done your work a bit quicker than I supposed, so it means very fast. Okay, so in this moment, I want each group to present what they think is suitable, and we'll try I don't know, maybe in whole group to create this list of 10 the most important things. So maybe we have a flip chart, which is free. Yeah. Honestly, I have no idea how we will manage to write it down on the one board, but I think we will figure it out somehow. Because in the end, I want to get those 10 the most important things which you think are relevant for the institution. So maybe you can start. Of course. I know those technical stuff. So, okay.
So we talked about open source education courses. Yeah, open source education courses, digitized collections, virtual tours, downloadable materials, AR, VR experiences, podcasts, social media presence, online events, issue of digital waste, shop online, surveys and questionnaires.
Okay, so can we get those, put it here in this?
Should I just?
Yeah, of course. Okay. I don't know how I don't know yet how we'll manage to do that. Oh yeah, great.
Basically, one of these that are the same, yes.
Okay. So we have the next group.
So, hello everybody. We have some things in common with the previous group.
Maybe we can get that here, and maybe we can try to combine those things together. I don't know. I really don't know what I'm doing. Okay. Last time I did it online, and there was mirror boards, so it was easier to move those things. Okay.
So, as you can see, we thought about digital archives, periodic videos, intensive presence on social media, digital access to sites, public voting, gaming, monitoring, which can be applied to several areas, but we focus on, for example, target groups, crowdsourcing, apps, online networking, fact check, online sustainability, and last but not least, footprint tracking.
And what do you mean by that?
We mean that maybe cultural institutions can act as a way to check, fake news, but also fake or misleading information about heritage, for example.
Okay, great. Very impressive. Okay, so the next group.
Sorry. So we've thought about a blog for the members of the organization, activities for the transition, like thinking about some audiovisual material to improve the accessibility, data analysis to create different experiences, access to previous research and educational resources broadly related to the material that the institution developed in the past, a database for partner organizations, a platform for receiving the user's view on what the institution is working on, so collection of data, digital experiences, tools, diversified according to different users, description of the users' specificities, recognition of the actual activities of the organization, gamification, and then webinars or symposiums to catch up with the latest trends in the field.
Can I get that? Yeah, Mike and that. Probably that is most interesting. Okay, thanks. I don't know how we'll be able to combine those things, but we'll see. Okay. And last but not least, you need to get a mic.
Problem. Yeah, so we were a bit more general, but we basically discussed, and I will not repeat what has been said already, but we essentially discussed about embracing digital transformation in order to achieve a set of goals in order for institutions to stay relevant. And the goals would basically be improving access to different groups, for different groups, ethnic groups, age groups, etc., with a particular intention to target vulnerable groups and to kind of include them, and to sort of foster democratization, collaborative projects. We talked about culture institutions trying to address power structures and to sort of partner up with fields that are sort of relevant to the 21st century. So, issues of social justice, issues of climate, of decolonizing practice, knowledge, etc. We were thinking that museums need to engage more in critical narration and self-awareness, basically, and again, to link to broader social issues. We talked about things like having, what Katerina was talking about earlier, basically having skills beyond just sort of art history, etc. So embracing interdisciplinarity, having digital literacy, being inherently carbon neutral and using sort of kind of, again, digital transformation to be sustainable. And yeah, just again, digital transformation in order to kind of make institutions a safe space for creativity and exchange of ideas.
Can I get that? Not the mic.
It's messy though.
but I will try to do what I want to do. Probably it will help. Okay. So my next question is, okay, I think we'll not be able to think about those terms and to make a list because we have probably not enough time to do that. Or maybe we have. Okay, so I will try. Have you ever had a course on copyright and those kind of stuff? So have you heard about the copyright? Okay, that's not good. I will try to think about those activities from the perspective of copyright, and I will ask, and I will, think which will be triggered by copyright, and then I will make, this short lecture about that, and we'll wrap up. So, digital archive, definitely it is copyright this is a copyright issue, so we need to know how it works. Videos, yes. And the content which is used in the video can be very important. Social media links, very problem of copyright. Digital access to site, copyright problem. Public voting. From the perspective of the computer program, because public votes need to be done by some kind of computer program, yeah, it is also a copyright material. Gaming, you also use copyright materials. Monitoring, I don't know. I have no idea. Crowdsourcing. It is from time to time. It is nowadays we think that this is could be alternative to copyright in some exchange. So it is somehow related to copyright. Apps, of course. Everything in the internet is online networking. Yes, you need to use computer to do that. Fact check. This is very important about the copyright because the facts are not protected by copyright, but the form in which they are presented can be protected by copyright, so it is also a problem. Online sustainability. What do you mean by that, once again? This is just a fancy word, what do you mean?
You cannot save everything.
What?
You cannot save everything.
Okay. So maybe not. Footprint tracking. This is GDPR, as I understand. Okay. So we don't know. Okay. The next things. Open source education, definitely problem of copyright. Digital collection, very important problem. Virtual tools, copyright protected. I don't know what's here. Oh yeah, copyright. VR experience, copyright. Podcast, copyright. Social media presence, copyright. Events, copyright. Digital waste. Okay, so maybe it's a bit copyright. Shop online, copyright. Online is protected by copyright. Okay, now we're getting very interesting. Block of... Yeah, sorry for that, but I really need interpreter.
So it's a block for members.
Block for members, yes, it's user-generated content, copyright.
So audiovisual material.
Copyright.
Data analysis.
Copyright.
Previous research and educational research.
Copyright.
Database of partners organizations.
Copyright and database protection. Copyright.
Platform for the user's view.
Copyright user-generated content.
Digital experiences tool.
Copyright.
Description of users, specificities.
Okay, I don't know.
Some description of the activities actually.
Okay, so copyright.
Gamification.
Copyright, of course.
And webinars and symposiums.
It's copyright protected. And I will not go through all of you because you have a bit more general, but honestly speaking, there is copyright here somewhere. I will take a photo of your work because I will also use it to think about those stuff later. So as you understand, most of those activities which should be or are taken by the cultural institution in the internet are somehow related to copyright. And copyright can be treated as a problem for those institutions to fulfill their missions. And I will try to show you how the copyright in general works. And this will be very general introduction. And also it is very messy to talk about law when you not talk about the specific law. In a sense that when I teach in Poland, I taught about Polish law. When I taught in English, in European level, I usually taught more general European level. And now we have, you know, international level, so it's just very general. But there will be a bit of flavor of European copyright, because I assume that you are most familiar with that. I don't know why, and we'll see how it works. Yeah, we are after that. Copyright and question and answer. I will talk a bit, and you can ask as many questions as you wish, and whenever you like. You can stop me, interrupt me. I like it. It's very nice. And also we have plenty of time, so we don't need to hurry. Okay. In a general way, as this is a slide from Europeana. Do you have heard about the Europeana? Great. Me too. So this is a slide from Europeana, because Europeana is a European virtual museum which tried to be relevant, and they try to fulfill their mission to collect things, but because of the copyright, there are lots of problems. And generally speaking, as you've seen, those kind of institutions need to take copyright into consideration. And why is it in general it is a problem from my perspective? Copyright was invented as a tool of creating markets for books. It was the origin of the copyright. And nowadays, it's not only about books, but it's mostly about every kind of creation, and it's cover everything, and it's not only affect the commercial interest in the sense that it doesn't show when we have two commercial companies talking with each other, but it affects users and end users, and also it affects those kind of institutions like heritage institution or cultural institution, which are not conduct their business for profit. So they have different mission, they have different aims, but still they need to obey the rules which was developed to protect the commercial interest, and that's why there is a clash. So if you are a cultural institution and if you want to show something, display, put something online, then you need to obey the rules which are more or less prepared for the market, not for the non-profit organizations. This is a definition of museum from ICOM, and this is from 2007, and as I understand, they are working about a new definition of museum, so I don't know when will come up. It is new? Yes? No, not yet. I think that they are working.
Controversy 2 years ago.
Yes, and they are working, yeah. So, okay, yes. Give them space. But in the end, as you can see, in general, museums are defined like a non-profit organization, and this is important for me because this is different from the companies, because companies have different resources and different aims, and also they are, focus on acquire, conserve, research, communicate, and exhibit. This is the mission of the museums, and those elements are problems from the copyright perspective. And nowadays, copyright trumps those things, in the sense that on one side we have a public mission of the museum, on the other side we have copyright, and in the end, you need to obey copyright. I don't know why it's like that, but this is how it works. Oh, this and this not. Oh, okay. Oh, no. Okay. So in general, when we think about the copyright, when you want to start to think about the copyright, in the first place you need to think about something which is called public domain. So everything, and this in general, there is something which is called public domain. So there are ideas and things which are not protected by anything. So this is a general space of freedom of use those things. But then you have a part in this public domain which is protected by intellectual property rights. The most important is, of course, copyright. The R symbol is for patent law, but also you have a trademark, you have database protection, you have geographical indication, and lots of other very interesting stuff which restrict access and use of things which are in a public domain. But when you look at the copyright, also you have something which is called permissible use. Also, it could be called exception and limitation to copyright or to patent law whatsoever. In general, it's permissible use. So there is, okay, even if you have an item which is protected by copyright, you can do some stuff with that which are prescribed in law. And we'll talk about those permissible use in a moment. When you talk about the copyright, now we have plenty of situations in which the copyright arises. As I told you, it started from books, but now we have works expressed in words, mathematical symbols, graphic signs, everything. You know, nowadays there was a very interesting judgment from European Court of Justice. It was called Infopack, and they said that even a short message which contained 11 words could be protected by copyright. So even those short things. So I think probably the memes are protected by copyright. This is very disputable, but in the end, everything. Artistic works, of course, photographic works, and this is very mass because this is a very complicated system how photographic works are protected, because in the end, copyright protects only expression and do not protect things which are facts, ideas, and things like that. And when you take a photo, usually you just reproduce something which is objective outside. So this is very tricky. When you can say, oh, this photo is copyright protected, because it is special, because it has this creation element, creative element, or this is just, you know, plain photo which there is no copyright. And there are a lot of problems with this area for cultural heritage institution, because, for example, when you have an object and you take a photo of that object because you want to put the object to the internet, the question is, of course, object is copyright protected if it's a painting or sculpture whatsoever. But when the photo is copyright protected, and this is very messy and ends up very huge discussion how it should work. Industrial design works, of course, it wasn't like that. Before, long time ago, you have all, if you had, you know, beautiful, for example, something from the, yeah, from glass making factory. Usually it was protected by industrial design, and after the industrial design expired, there was no copyright protection. But now we have a cumulative protection, so you can get industrial right protection and also a copyright protection. So you have two layers of protection in one thing. Architectural works, musical works, theatrical works, and audiovisual works, which are very complicated, of course, because there are lots of different rights there. And as I told you, now we live in a situation in which we have a cumulative protection of intellectual property rights. So one object can be protected by different intellectual properties. So for example, you can have a copyright, you have something which is called related rights, which are designed for producers. And we'll see example in a moment. Database rights. So this is very messy from the perspective of cultural institution, because if you want to put something on the internet, you need to check who is the author, who got a copyright, if there is any related rights to that, who get the related rights. And also there could be one author, co-authors, plenty of authors, and this start to be very messy. You need to go through this process to put simple photo on the internet. And also, there are another layer, especially this is a problem for newspapers, if you want to put the newspaper on the internet, or for photos, because you have a copyright protection, but the other layer of protection is another rights like privacy, privacy rights. So for example, if you want to publish a photo about some kind of event, and on this photo there are people, the people have also rights to not to be on display. So you need to find those people and talk to them if they want to or they don't want to be in your collection. And the cumulative protection in practice is very tricky. So for example, if you have a CD with songs, so you have a copyright, there could be one author, plenty of authors, you need to find all of them. You have right to performance, because somebody needs to sing a song or perform the music like an orchestra. They have a separate set of rights. And then you have rights to phonograms, which are assigned to producers of those CDs. So you need to understand all this mess. And this could be even more tricky, because, for example, if you have a piece of thing like a newspaper, in this newspaper there are things which are protected by copyright and those related rights, and on the other hand, there are parts in this piece of newspaper which are not protected by any rights because they are in public domain, and you need to decide which is which. This is all what you need to do. As I told you, copyright does not apply to idea, but it does apply to material expression of that idea. So it is also very tricky to say what is a fact. For example, Titanic, sink. This is a fact. And when this fact starts to be a copyright-protected work. This is very tricky, and it generates a lot of problems. So generally speaking, what is a copyright? Because I was talking, and now to a conclusion. First of all, it is exclusive right. If you are an owner of the copyright, you get an exclusive right to distribute the work, to communicate the work to the public, and reproduce the work, to make copy of the work. This is language. This is European directive language. So in different countries, it could be called a bit different, but in the end, it covers a usage of piece of work. It's automatic, and this is very problematic, because most of the intellectual property rights, especially industrial property rights, patents, trademarks, and so on and so forth, they need to be registered to give the exclusive rights. Copyright is just born automatic. If you create something, you get a copyright. And nobody will tell you this is copyrighted or this is not copyrighted. You can say, okay, I wrote this book, so it is copyrighted, but then you will need to go to court, and the court will decide that if this book is really copyright protected or not. So this is also very, vague in practical terms. It's temporary. All intellectual property rights expire after a certain point of time, and copyright in general, I would say, expires after 70 years after the death of the author or the last co-author. But this is very tricky and very messy, and I will show you why in practical terms. It's also territorial. This means that in each country you have more or less harmonized copyright protection, but in the end there are different sets of rules, different sets of exceptions, and you need to, if you want to put something on the internet, you can do it, just, okay, I do it in Poland, so I have two options. First, I just fact check for Polish copyright, and I block access to this website from outside of Poland, which is just stupid. Or, if I want to display on the internet for everybody, it means that you need to take in consideration all those legal stuff. So it is quite, interesting stuff to do by the lawyers, but not for the normal people. And also, you can transfer your rights. Because copyright is divided in two branches, I would say, two elements. First is economic right, and you can assign that, transfer the right. And also there is a moral right, so you cannot transfer. They are always stay with the author, and the author can use it all the time. So what are the rights? This is from the perspective of European law. So economic rights, as I told you, this is a reproduction right, so make copy, right to communicate the work to the public, and this is a right which is triggered when you, for example, put something on the internet, because you are communicating the work to the public. There is distribution right, so it is the right to resell, to sell the material object which contains the copyright material. There is also a rent and lend right, which means that if you are the author, if you have a copyright, you also you need to give a permission to other people if they want to rent or lend your works. And there are also parts of copyright which are not harmonized in the European Union, but are very important. For example, public performance. So if I want to stay here and, for example, sing a song, this is probably would violate a public performance right, because I don't have a copyright permission to do that. There is also exclusive rights of exhibition. So if you want to make an exhibition from the object, you need to have a permission from the author, honestly speaking. Screening, presentation, and also a very complicated area of derivative works, because copyright does not protect only, for example, a book, but also it protects things which can be based on this book. So, for example, if you want to make a film based on book, you need to have a permission from the author. If you want to make a translation of the book, you need to have a permission from the author. So all this stuff, which can be used also a creative job, because when you do something, which is based on the other word, you make your own creation. But still, to do that, you need to get a permission from the original author. In European Union, moral rights are not harmonized, so you will not find any moral rights in European Directive. But what are the moral rights? The first is the right to attribution. So if you are the author, you have a right to put your name on your work, to be attributed to your work. And of course, there is also important right to object any modification which is derogatory to the work. So it is quite difficult when you want to criticize something, because usually it is derogatory to the work, so it is tricky. And the related rights, as I told you, there are lots of them. There are performer rights, which assign to performers, right to phonograms, videograms, rights to broadcasters, and database rights. And now, because we have beautiful new directive, which is called Digital Single Market Directive, and this beautiful directive introduces a new related right, which is assigned to newspapers. So it will be another layer of protection. So as you can see, when you combine those two things, the public mission of institutions with all those rights, it means that you need to forget about your public mission and start to be a lawyer to think how to do all those stuffs, because otherwise you will be illegal and your institution will have lots of problem. This is very important, because the physical ownership of some kind of object does not mean that you can do something which triggers copyright. So if you have objects in your collection and they are protected by copyright, you cannot freely do whatever you want with them. You need to have some kind of copyright permission. So how cultural heritage institution can use the copyrighted works? Because this is the essence of our discussion. So first of all, you need to make a process which is called right clearance, which means you need to know everything about the particular object. You need to know who is the author, who is the producer, when was created, when the author died, and if there is only one author, if there are co-authors, everything. You need to go through all this process just to start to think, how can I use the object? Because after I go through the right clearance process, then I can say, okay, this particular object, for example, is in public domain, so I can use it freely, no problem. Okay. Okay. This particular object is not in public domain, but maybe there is some kind of exception in copyright which allows me as an institution to do something with this object. Okay. And if those two elements are not relevant, then you need to get a consent from the author, not from the author, for the right holder. Because I told you that the copyright can be transmitted. So you need to know who is the author, but also you need to know who is the owner of the copyright, because they could be two different people. And if, for example, somebody inherits the copyright, and there are 10 people who inherit one copyright for one material, so you need to get 10 permissions. So it is quite messy in practical terms. So if something is in public domain, you can use it freely. And in general, in public domain, you have two categories of things. So works that have never been copyrighted. For example, Mona Lisa was created in beautiful times where copyright was not in the place, so you can use it. But also when the copyright expires. I told you that copyright is temporary, but this problem of expiring copyright is quite messy in practical taste. But in the end, you can use those things freely if you will say, okay, this is in public domain. But what does it mean that something is in public domain? There is no one single definition for that. As I told you, copyright is changed in different countries. So in different countries, one material can be in public domain and in another country not. So you need to know all those things to say, okay, this is copyright. Okay. In most countries, it is 70 years after the death, but there is a very nice exception to this nice rule. It is USA, because there is also a general rule that there is 70 years after the death of the last author. But if the work was so-called work for hire, so in practical terms, the work was made for the corporation, then the copyright lasts 95 or 220 years. And this regulation, which was passed, because they make copyright longer and longer, because, and you can see the sign, this is called also a Mickey Mouse Act, because it was introduced when the copyright to Mickey Mouse was just going to expire, and Disney was not so happy about that. So, okay, so we'll change the law and everything will be back on track. In generally speaking, you can say that if something is created before 970s, it is probably in public domain. It's probably in public domain. If something was created between 970s and 1950s, it's probably you need to check it very thoroughly, country by country, and so on and so forth, because it may be in public domain, may not be in public domain, and definitely if something is after 950s, it's copyright protected, so this is how it generally works. But this is a simple decision tree made by one of the European organization for European, how to determine in Europe when something is in public domain or not. This is only for Europe. And when I talk with Martin, who created that, or who supervised creation of that, he said, oh, but this was created 5 or 10 years ago, and now it's outdated. So it is even more complicated nowadays. So if you want to do it yourself. Very nice. There is something also which is very, which you can see at a few websites. This is a public domain mark, which was introduced by the Creative Commons. Have you ever heard about the Creative Commons license? They also, so they create license, but also they create this mark to put something, to tell that something is in public domain. It is just information, and you cannot rely on that in the end, but you know, this is how it works. When you look at the second part, as I told you, okay, first, public domain. The second, so in public domains for all stuff. Second is you need to look through the copyright exceptions. And when you go to this web page, copyright exception, this is a web page provided by the Europeana, as I understand, not Europeana, by Comunia, and it is only for European Union, because we have a very nice directive which is called InfoSoc Directive, the Information Society, blah, blah, blah. And there you are a list of 27 exceptions which are not mandatory. So in each country you have a different exceptions and different implementation of those exceptions. So if you want to do, even in Europe, something, you need to do this country by country and check if particular exception was implemented first, and then you need to say, okay, this was implemented, but how it works in this country, because it changed a bit. And from the list of the exception for cultural heritage institution, there are 4 main exception, optional. In Poland, we have implemented all of them, but in many countries, is not the case. So there is a preservation exception, which means that to some extent, cultural heritage institution can make copies of the work to preserve them, not to show them to anybody, just to copy and put them in archive, that's all. Very small exception for research and private study in dedicated terminals. This is very nice terminology because it is from the beginning of 21st century, dedicated terminals. So it means that if you have this kind of organization, you can put things on the internet, because, but not in the internet, but into your intranet, in the sense that you can have the computer in your site and, okay, you can tell the people you can go to this one particular computer and you can go through our database. That's all. You cannot do it on the internet. There is small exception for advertising and public exhibition. So you can probably do something like it's called catalogs, but you cannot sell them, but you can do it for advertising. That's all. And public lading derogation, because as I told you, copyright also covers the lending process. So if there are libraries, technically speaking, library cannot buy a book and lend them to anybody. They only can do that because there is exception which allows them to lend the books. Without that exception, we have no libraries at all. There are also 2 new mandatory exceptions in copyright in the European Union. First is about text and data mining, and this is connected with digitalization on making the metadata and process of using work to, I don't know, train artificial intelligence and so on and so forth. And this is exception which we are now waiting for the implementation, because the implementation date was in the June, but no country did it yet, so we are waiting how it will looks like, but this is also very, very narrow exception. And then also is surprise, a new exception mandatory for preservation of cultural heritage, and this is mandatory, so hip hip hooray, in European, cultural heritage institution will have the right to make copies of the work, to preserve them, but not to show them to anybody, just to preserve them and put them in archives, so forever. Very nice. Nicely done. Also, we have a special regimes which try to overcome some problems with copyright. First is orphan works. Those are works which you cannot identify the author. You don't know what was the author. For example, you have plenty of photography in your archive and you cannot display them because probably most of them are protected by copyright, but you don't know who is the author. So you can use the copyright directive and copyright mechanism for orphan works, but this is highly complicated because before you doing that, you need to go through very diligent search and need to put a lot of effort, and you need to document that I took this photo and I tried to find the author and I failed, and now I can do that. And it doesn't mean that if you put this on the internet, everything will be okay, because if the author will come up and say, okay, this is my photo, and you infringe my copyright, and you need to pay for that, even you go through this very thorough process. So this is how it works, very nice and very useful. it doesn't work. You know, it's few works. There is a register in European European Intellectual Property Office. Few works there are. And this is a new mechanism, which is the second, which is called out-of-commerce work. And this mechanism will be also implemented because of the Digital Single Market Directive. But now we are waiting for how it will look like in reality. There is also a bit of search. You need to do it, but this is, you know, not so diligent that it's in case of orphan work. So maybe it will be more practical in terms, but we will see. This is a new stuff. Okay, so, but in general, if you want to make an open source collection, you cannot do that. You cannot rely on any kind of an exception, because there is no exception in copyright to publish entire collection in the internet. You need to go item by item, element by element. This is a different in when you talk about out-of-commerce work, because there is probability that there you'll be able to do it in a more massive than by item, but in general, there is no such an exception. So you can rely on the things from the public domain, and this is what Europeana mostly does. They have things from public domain, or you need to have a consent from right holder. And how you can get the consent from the right holder? First of all, you can have a simple consent. It is useful from time to time. I talk with the professionals from different museums, and they say to me, okay, if we think that this author is not problematic one, we just send them an email, and if he'll send it back and say, can I use this in my online collection? And they say, yes, okay, there's no problem, okay. So from time to time it works, but it's not so legally binding, or it is very easy to withdraw, so this is a problematic from the perspective of creation and collection. You can use the CC license. From time to time, there are lots of people who release their content on CC license. You can find those things on the internet. There are lots of, you know, aggregators. Even in Google, you can, in the Google search, you can put this element, and they will display only things which are on the CC license. You can get a traditional license, which is the most common and the most practical thing, not practical, the most safe way to do. And also you can acquire rights from the author, so you can buy them for the institution. And but all those stuff you need to do before you want to display anything on the internet. And usually you can do it by direct contact with the author, but not the author with the right holder. You need to know who is the right holder, and you can ask them for one of those options. And sometimes you can do it by things which is called collective management organizations, which are societies which represent artists, and they can give you this kind of license. Of course, you need to pay for that. I will not go point by point about the copyright, about Creative Commons license system. You can find it on the internet. But there is, in general, there are 6 kind of those license. Some are very free, which enables you to do lots of stuff with the thing. But also there are licenses which forbid you, for example, to commercially use particular item, or to make a derivative works based on the item. So you need to go point by point and to analyze particular item was released on particular Creative Commons license. And at the internet also, at the website of the Creative Commons, you can find this thing which is chooser, and it helps you to choose a particular license for your particular purpose. They ask you a question, and when you answer the question, they will say, oh, based on these answers, you should use this kind of license. So it is very helpful if you are not a lawyer and you don't want to read all those, you know, very interesting documents. And then you have this collective organization, which represents a group of copyrighted and related right owners. Usually when you want to display music or you want to make a film festival or whatsoever, you go to those kind of organization and they will give you a permission. You need to pay for that, and this is how it works.
Okay, may I ask you a question?
Yes,
Great.
at least.
I work in several NGOs.
Okay.
And we are organizing some kind of, I don't know how to say it, discussion evenings, for example,
Yeah.
film projections and so on. Should we report it
Yes.
to anywhere? If yes, what will be the consequences if we won't do this?
If you want,
If we will not do this?
you will infringe a copyright. So if this organization, I will skip one more, okay. If this organization, which is called ZAIX in this probably situation, or SFP, film makers and audiovisual producers, they will find out that, and they will, because they have their agents, and they go to places and look. And this is not a joke, this is how it works. And then they will fine you, and they will ask you to pay money, and if you will not be willing to do that, they will go to court and they will get court order to pay you the money. And if you will not do that, they will have send you, a prosecution.
I just asked because I thought that maybe the non-governmental organizations, maybe they have maybe the possibility to show the films for free or so on.
Okay, once again, this is my failure, so okay, I will take it for me. As I told you in general, you can do that when you have an exception for particular use, and there is no such a particular use for those kind of organization. If you are a school, for example, or we can call it in Polish legal system, educational establishment, and which is a formal name, then, for example, you can do that freely. But if you are not in the scope of this kind of exception, and you are not as a non-governmental organization, you can't do that. Of course, in practical terms also, those CMOs, they have different fees for commercial and non-commercial events. So if there is a case of non-commercial events, the fee is a bit lesser than commercial event. But still, you need to go there and take that. And the problem, for example, with a film is that you not only need to go to SFP, but also you need to find the producer or distributor of the film. Because SFP or ZAIX, they collect money for one areas, for example, how to say it, only for one, for one layer of the copyright protection. But still you need to have another consent from the producer. So it is, in practical terms, it's very, you need to find both people. And the ZAIX and SFP will not tell you who is the distributor. You need to find it out by yourself. This is how it works. The main element of the system of CMOs is that they have a duty to license, and they have very rare situation in which they can refuse to license, but still it can be the case. Okay, so this was the copyright, and we have 10 minutes to discuss and to questions and whatsoever.
If I may have a short question.
We need the mic.
Oh, okay.
Okay.
He didn't have it. All right, thank you for the presentation. Quite a lot of information to take in, but I'm sure it's all it's really useful. We need to know all these in our field. I'm just curious. There is a situation in Romania. So there is this private company. It's called Bookster, and they offer a service to the corporate world. So they basically allow you, if you're a corporate employee, to borrow books for a certain extent of time. And they make a profit out of it. And right now there is kind of a conflict back home between the publishing houses and them, because they're like, the publishing houses are like, how can you, it's not ethical to make money out of borrowing, like you bought the books once and you're just borrowing them, lending them to all these corporate employees and you make money out of it. And I was wondering, like, what's your take on this? What's your perspective on this, both from an ethical perspective and the copyright aspect? Thank you.
From copyright perspective, it's quite easy. It is protected by copyright because I told you the copyright also covered the land, right? And land and rent, and this probably is renting because you rent something for money. So it's covered by the copyright, so they need to have a permission to do that. This is out of the question, but and this is how it works. And as I told you, the case of the libraries, which they lend something without money element, they also need to have a permission. They don't need because they have an exception for them, but there's a specific exception, and we as a society pay something which is called public lending fee, and all those libraries need to give money to authors because they lend things. So this is how it system works. I don't like copyright, so I think it should be like that, you know. But in reality, when you have one item, and if you want to lend that, this is covered by copyright. In most, yeah.
In the Netherlands, they had the same thing, but with e-books. So they bought one e-book and then lent the e-books, but well, it was a mess and they had to stop.
I can to intervene with that because there was a copyright dispute and this ended up in the copyright in the European Court of Justice because. Okay, never mind.
Yeah, it was Tom Cabinet, maybe.
Yeah, Tom Cabinet, of course.
Yeah, yeah. I used to work for him too.
Okay.
For a short while. What I wanted to
so
ask.
You know the case.
Yeah, I do. Yes, things are changing very fast. So for the e-books, they had to make a new law, I think.
It's different, you know. The e-books are a situation in which is covered by the typical copyright.
Okay.
Out of the question. There was a judgment before that about the copyright protection to computer programs. And there, in computer programs, you can do that.
Okay.
But you cannot do that with the e-books. Why? Mystery of law.
So do you think, can we keep up, or is it impossible?
I do my PhD in political economy of copyright and intellectual property in general. I think the system is not suited for our times, and we need to rethink it from the beginning. From my perspective, you cannot just, you know, oh, here we can change a bit and we're okay. It doesn't. From my perspective, we will end up with a total mess, and we are ending up with a total mess.
My question is more practical. So I am working, for example, in an organization, and we do have an in-house designer and an in-house photographer. Okay. We do an exhibition, we gather material, we put them online, and we do get this GDPR from the participants. So who owns the rights of the material in our social media?
Oh, it depends. It depends on the contract we have with those people. Because in general, and this is a Polish perspective, but this is more or less how it works in Europe. If you have an employee in an employment contract, usually the organization acquires the right if the employee is hired to do things like that. So, for example, if you employ a photographer, probably the copyright will be assigned to organization. How it is done technically is different stuff. But if you don't have an employment contract, but that other kind of contract, civil contract, I would say, then you need to put a special provision in the contract to assure that the institution will acquire the rights. If not, the rights will still with the photographer or the graphic designer whatsoever. So we need to acquire the rights.
So it would be interesting, for example, to in the employment contracts to have a specific
Yes.
phrase that all the content belongs, that will be ever created belongs to the organization.
but
Even if it's not, because I'm thinking now, okay, I'm not the photographer, and I'm not the designer, but I am here today and I'm taking pictures as a project manager, and then I will give them to our social media manager, and they will upload them. So practically, if in the contract is not mentioned that I can do that, I do have the rights.
yes, in most
Thank you.
case scenarios, it's how it works.
Very good, thank you.
Very practical. Any other questions? Okay. Because I need to show a few slides more. Last questions. And we have 3 hours on the bus, so I can answer all of your very interesting questions for the copyright.
Okay, it's very practical. Some cultural heritage institutions cannot afford to have an in-house lawyer. How do they manage? Is it done pro bono sometimes, or are there online resources that show that map that you showed for the public domain, for example?
I will answer your question when I will show you what I'm going to show you. In general, this was a traditional approach to copyright that in cultural heritage institution that we have a creator who creates the work, we have cultural heritage institution who preserve and provide access to work, and then we have the audience who look at the work. This was a traditional how it used to be done. Now we know, and because of all of your ideas, it's different because the creator uses a different content. The institution wants to enable their audience to use those things and to do with them some stuff. And then we have the audience who wants to reuse that and to use it in this life. So this is something which is not copyright clear. You cannot do that easily from the copyright perspective. That's why there are lots of initiatives to create more open way of cultural heritage institution to work. And for example, there is I don't know how to say, a movement about the open GLAM. GLAM is, you know what's GLAM? Okay, so it's open GLAM. You can go to this page. There are lots of nice materials, but also they want to create some kind of declaration, and they are working on this declaration, how those institutions should engage in open movement from that perspective. And also, as maybe I also work in the project which is called Indices, and this is also a European-based, very interesting project. And we are dedicated to measure the impact which cultural heritage institutions have for societies, but not only from economic point of view, but more broad. And we are trying to show how it works, because nowadays Commission doesn't, believe that there is any, value and social value in those, very strange activities. So we are trying to convince them that there is the layer of that. And you can go to this participate web page. We are working on that. And then there will be something which is called, we are working on that self-assessment tool, which will be able to help people to manage those stuff. But I'm also responsible to prepare legal recommendation about the copyright change. And the one problem is exactly what you said. Copyright as a system is highly complicated, and most of those institutions have no money for lawyers, and also they don't have money to pay for those licenses. So I want to say in this paper that, okay, my dear Commission, if you really want to have a copyright, if you really want to make a cultural heritage institution to obey copyright, you need to give them tools. So money for copyright fee and money for lawyers who understand the system you created, because it's too complicated for normal people. And now, last but not least, so what is the innovation in law? Innovation in law, of course, is the change of law. And you need to understand that the law should be adjust to reality, and copyright is not. It's still based on ideas which was developed in 19th century, in 18th century, and it makes things more messier and messier. And the second element is that the change on law doesn't, change by themselves. You need to engage in the democratic process. This is the only way how the change can be done. There is no other option. You can't, expect that, somebody will come and change the law for you, because from the history we know that if there is any change in copyright, it's only in one direction, and it makes more harder to people to use the copyright. So if you want different situation, you need to engage in this process. And I thank you for your attention and for my. And it is of course on the CC license. You can do whatever you want with this presentation. And for people in Poland, if you have a problem with sleep, you can read my book about the history of copyright. And this is also released free and page, because we have something which is called free books, wolne licencje, free books library. And there are lots of books from public domain. You can download them, read them, and do whatever you want. And you also can find this book from me. Thank you very much.